Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. First on the docket, we have an update on the Joshua Brown case, the witness in the Amber Geiger case who was killed this week. Second on the docket, two very interesting cases related to criminal law argued before the United States Supreme Court. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thank you for tuning in to our channel. We appreciate you watching. If you like the channel, please subscribe. If you like the video, please hit that thumbs up. Hit that little bell if you'd like to receive notifications of when we go live or put out new content. And as always, leave a comment. We want to know what you think. First on the docket, Joshua Brown. For those who don't recall or not really sure what's going on, Joshua Brown was the neighbor, a key witness in the Amber Geiger homicide trial that took place last week in Dallas, Texas. Mr. Brown was hesitant to testify because apparently he believed he had been targeted previously last year when there was a fight at a gentleman's club in Dallas. He was shot and a friend of his was killed. Needless to say, he testified. Word broke late Friday evening that Mr. Brown had in fact been killed, and a lot of people speculated that it had something to do with his testimony. I reserved judgment because we had no information about that. In my gut, I didn't think it was going to be related, and now we have information. There are 3 people that are suspects in this particular case, and they are all presumed innocent and should be given the presumption of innocence until proven guilty in a court of law. First, 20-year-old Jacarice Mitchell, who was wounded and ultimately taken to a hospital. The police are still searching for Thaddeus Green, and a Michael Mitchell was also in custody in Louisiana and being returned to Texas. Mr. Mitchell told the police when he was arrested that Mr. Green had contacted Mr. Brown to buy drugs. They ultimately drove from Louisiana to Dallas to meet Mr. Brown. Apparently everything was fine. The conversation escalated into a physical confrontation, whereupon it is alleged that Mr. Brown shot Mr. Mitchell and then Green shot Mr. Brown, which ultimately resulted in his death. Mr. Mitchell states that he was taken to the hospital, and the other 2 suspects fled back to Louisiana. And I'm telling you, this is, I had a case almost exactly like this 2-3 years ago. People drive up from a different state. The guy who's selling the drugs is getting all the stuff together. In this particular case, it was marijuana. And they're in this little basement. Nobody knows everybody. Nobody trusts anybody. Everybody's armed. Somebody moves wrong, got a little twitchy finger. Next thing you know, in a little room about 6 by 6, you've got 3 people shooting guns, 3 people dead. It was just a complete chaos. Fortunately for me, since my firm has a very strict policy of only representing innocent people, my client was asleep in the back seat because he just wanted to come to the Denver area to come enjoy a dispensary to obtain marijuana. Never did. Didn't know necessarily what was going on. Certainly had no idea anybody was going to get shot. But that just shows you, you have to assume when there's a drug deal, somebody is packing heat, if not everybody. That's why it's so dangerous. That's why guns and drugs are so bad, and they complicate everything in the criminal justice system. Now, just to be fair, a lot of people really came to like Mr. Brown, and he came across as a good guy. On the stand, that's for sure. But when they searched Mr. Brown's house, they confiscated some 12 pounds of marijuana, 149 grams of THC cartridges, and a large amount of cash in the apartment. So, unfortunately, things did not work out well for Mr. Brown, and hopefully the people, if they're responsible for his death, are brought to justice. Now, the next thing on the docket today, a couple of interesting cases being argued before the Supreme Court this week, and I think it's worthwhile going over a couple of them. The first case is James Cowler versus the state of Kansas, and this has to do with the insanity defense. So in summary, in 2009, James Cowler shot and killed 4 members of his family, his 2 teenage daughters, his ex-wife, her grandmother, and during the weekend after Thanksgiving, Cowler's young son was at the scene, but ran out the back door and was not physically harmed. When Cowler's case went to trial, an expert testified that Cowler had been so depressed at the time of his shooting that he couldn't help himself. However, under Kansas law, Cowler couldn't argue that he was not guilty by reason of insanity because Kansas does not offer an insanity defense. In 1995, the state replaced the insanity defense with a new law that allows a defendant to argue that he could not have intended to commit the crime because of his mental illness, but makes clear that mental illness is not an otherwise defense. Monday, the Supreme Court heard oral arguments on the constitutionality of the state's decision to abolish the insanity defense. The justices appeared to be closely divided and had a wide range of concerns, ranging from the perceptions that the state's rule is a departure from past practice to skepticism that even if an insanity defense were available, Cowler wouldn't qualify for it. Arguing for a Cowler, attorney Sarah Shroop began by emphasizing that for centuries, a defendant's culpability hinged on his ability to distinguish between right and wrong. The insane, she stressed, lacked the capacity. Justice Ruth Bader Ginsburg asked whether a state could decide that it wanted to rethink the insanity defense, creating this prospect that somebody could be found guilty, but nonetheless insane, and then committed to a psychiatric hospital instead of a prison. Would that violate the Constitution, she asked. Shroop pushed back, arguing that someone who is insane historically could not have been subject to prosecution at all, and a conviction, she added, could carry a stigmatizing effect. Now, Justice Samuel Alito worried aloud that if the general rule were that a defendant couldn't be convicted if he believed that his actions were moral, it would result in a revolutionary change to criminal law. All that Cowler's proposed rule would add, Alito continued, is that the defendant's belief be caused by a mental disorder. But it has been calculated that 1 in 5 people in the United States has some mental disorder, Alito observed, which would mean that many people would be able to raise an insanity defense if Cowler prevailed. Shroop again countered that the key question is whether a defendant is able to distinguish between right and wrong. People who have a mental disorder should be given the opportunity to at least try to make this showing to a jury, she told the justices, and juries in the state that still offer an insanity defense have been able to draw this distinction. But Justice Brett Kavanaugh was uncertain whether juries are in fact capable of doing so. Legal experts, Kavanaugh suggested, believe that juries may not be able to parse these fine concepts. Why isn't it reasonable, Kavanaugh asked, for a state to try to address this problem by taking away insanity as a separate defense and letting the jury consider the defendant's mental status as part of criminal intent at a sentencing? So they haven't necessarily abolished the insanity defense. I think that's a bit of a misnomer, Kavanaugh argued. Both Alito and Chief Justice John Roberts expressed some doubt that even if the justices were to rule for Cowler, it would make a difference in his case. Roberts cited some of the evidence of Cowler's mental state, noting that he had been described as someone who has thrived on self-importance and valued the perception that he had a perfect marriage. It may not be the best way to order your life, Roberts said, but it isn't necessarily evidence of insanity. Alito echoed that thought a few minutes later, characterizing Cowler as an intelligent man who sneaked up to the house owned by his ex-grandmother. Cowler killed his ex-wife and granddaughter and executed his teenage daughters. Alito emphasized, but spared his son because he didn't think the son was siding with the mother. This is the stuff, Alito asked somewhat incredulously, that you are going to argue that Cowler didn't know right from wrong? Justice Neil Gorsuch wanted to know how broadly an insanity defense would need to be made available if Cowler prevailed. Would it be required for all felonies, he queried, or would it sweep more broadly than that? Shroop responded that it should be applied everywhere, but she tried to give Gorsuch some comfort by pointing out that it is rarely used defense. It's invoked in less than 1% of the cases and successful in only a quarter of that. Now, Kansas Solicitor General Toby Krause faced questions from some of the court's more liberal justices who feared that the state's rule would result in the conviction of defendants with mental illnesses. Justice Sonia Sotomayor observed that Kansas's rule, by focusing only on whether a defendant intended to commit the crime, would not excuse someone who would have been considered a lunatic in the 15th century, for example, someone who hears voices. Such a defendant, Sotomayor said, might know that he is killing someone, but have no ability to say no. Justice Stephen Breyer joined in, asking Krause about two different defendants, both of whom have been certified as totally insane. One defendant kills someone he thinks is a dog, while the other kills someone he knows is a person because he thinks the dog told him to do it. When Krause acknowledged that the second defendant would have the kind of criminal intent needed for a conviction because he intended to commit the crime against a human being, while the first would not, Breyer pressed him then, asking, why should they be treated differently? Arguing on behalf of the United States in support of Kansas, Assistant to the Solicitor General Elizabeth Prelonger cautioned the justices that ruling for color might create more problems than it solved. Even if the states that recognize an insanity defense, she emphasized, there is no agreement on when mental illness should excuse criminal responsibility. Offering an example, a case in which a defendant hears voices that command him to kill to save a human race, she told the justices that in a substantial number of jurisdictions, the defendant still would not be able to invoke an insanity defense. Justice Kagan appeared unpersuaded. What you seem to be proposing, she told Pregler, is simply a basic intent requirement that doesn't have anything to do with insanity. But looking back at history, Kagan noted, there's just a ton that suggests there's something more that the defendant be able to form an intent to kill. Now, a decision in this case is expected sometime next year, and this is an interesting case because, yes, it relates to the insanity defense, but it really cuts to the heart of mental illness, and it's becoming more and more prevalent in the area of criminal law and whether people can use it as a defense to avoid criminal responsibility. That was a lot of talking. Good thing I have my Crime Talk mug here. All right, next on the docket. Next on the docket, in the second case that really had to do a lot with criminal defense this week, argued for the United States Supreme Court, was the cases regarding the non-unanimous jury rule. See, last year, Louisiana repealed a state law that allowed a criminal defendant, except in a capital case, to be convicted without a unanimous verdict from the jury. But the change only applied to crimes committed on or after January 1 of 2019. So the Supreme Court heard oral arguments in a challenge to the constitutionality of Louisiana's non-unanimity rule filed by an inmate who was convicted of a 2014 murder. In recent years, the Supreme Court has turned down similar challenges, but both the court's decision to take up the appeal and today's oral argument suggest that the justices may be ready to strike down the non-unanimity rule, which is still used in Oregon once and for all. But complicating the debate over the non-unanimity rule is the broader ongoing dispute over the importance of adhering to precedents, especially as controversial issues like abortion rights have arrived at the court. So the inmate, Evangelistio Ramos, has maintained that he was not responsible for the stabbing death of a Trinice Fenderson, whose body was found in the trash can in New Orleans. After 10 of the 12 jurors on Ramos's jury voted to convict him, Ramos was sentenced to life in prison at hard labor, and a state appeals court upheld the sentence. The Supreme Court agreed to weigh in on this case last spring. Now, the Sixth Amendment to the Constitution establishes the right to an impartial jury. However, when they were originally enacted, the first 10 amendments to the Constitution, collectively known as the Bill of Rights, they were interpreted as applying only to the federal government and not to the states. Over time, the Supreme Court ruled that some, and eventually most, of the Bill of Rights also applied to the states, a doctrine known as incorporation, through the 14th Amendment to the Constitution, which bars states from depriving anyone of life, liberty, or property without due process of law. And earlier this year, the justices ruled unanimously that the 8th Amendment ban on excessive fines applied to states through the 14th Amendment. So in 1972, in Apodaca v. Oregon, the courts ruled that the 6th Amendment guarantees a right to a unanimous jury, but that such a right does not extend to defendants in state trials. The court splintered into 3 different groups. 4 justices would have ruled that the 6th Amendment does not require a unanimous jury at all, while 4 others would have ruled that the 6th Amendment establishes a right to a unanimous jury that applies in both state and federal courts. And Justice Lewis Powell provided the controlling vote. He believed that the 6th Amendment requires a unanimous jury for federal criminal trials, but not for state trials. Arguing for Ramos today, attorney Jeffrey Fisher emphasized that Louisiana was not defending Powell's vote in Apodaca. The state's failure to stand by the vote makes sense. Fisher suggested because the vote flouted precedent at the time and is now merely an isolated relic of abandoned doctrine. Instead, Fisher noted the state has resorted to arguing that the 6th Amendment doesn't require a unanimous jury verdict at all. Now, Fisher quickly ran into a series of questions about the importance of stare decisis. That's the doctrine of adhering to precedent unless there is a good reason to depart from it. Justice Samuel Alito was the first justice to raise the issue, telling Fisher that Ramos was, quote, asking us to overrule Apodaca. And last term, Alito added, the majority was lectured pretty sternly in some cases about overruling the court's prior cases. Observing that the extent to which one side has relied on an earlier decision is an important factor in deciding whether to overturn that decision, Alito suggested that Louisiana and Oregon had relied on Apodaca in thousands of cases, a far greater reliance, his question seemed to indicate, than in some later term cases in which justices overruled a precedent. Justice Kagan pushed back against Fisher's argument that the courts could overrule Apodaca because that the trend toward incorporating the Bill of Rights leaves the decisions as an abandoned relic of the past jurisprudence. We tolerate a pretty significant degree of diversity in state criminal procedure, Kagan said. Perhaps, she continued, this is not the kind of anomaly that should concern the justices very much. But Ruth Bader Ginsburg echoed Kagan's thoughts. In its decision last term in an excessive fines case, Ginsburg stressed the Supreme Court specifically recognized that the 6th Amendment was the one exception to complete incorporation. Fisher also fielded questions about whether a ruling for Ramos would open the floodgates in both Louisiana and Oregon, prompting inmates to challenge convictions that became final long ago. Alito asked, will I see you up here in a term or two arguing that it is a watershed rule of criminal procedure that applies retroactively? Other justices tried to reconcile Ramos's proposed rule with the Supreme Court's 1970 ruling allowing 6-person juries. If only 6 minds need to agree to convict, Ginsburg asked, why shouldn't 10 be enough? Fisher responded that the purpose underlying a unanimous jury rule involved not the number of jurors voting to convict, but the degree of the unanimity, and the extent to which requiring unanimity promotes effective deliberation and ensures that a defendant is convicted by a cross-section of the community. Now, Chief Justice Roberts was unconvinced. I'm not sure that's self-apparent, Roberts responded. Fisher may have faced some tough questions, but Elizabeth Murrell, Louisiana Solicitor General, had an even harder time during her half hour at the lectern. Murrell acknowledged that the 6th Amendment does indeed require a unanimous jury, so that the only question before the court is whether the right to a unanimous jury applies to the states. Louisiana's prospects are concededly not very good, after last term's ruling that the 8th Amendment excessive fines clause applies to the states. Murrell got into hot water when responding to a question from Ginsburg about whether the state was asking the court to take up a question that it had already answered in Apodaca. Murrell suggested that Powell's decision in Apodaca was not clear and that the court had rejected unanimity back in 1972. But Kagan and Justice Brett Kavanaugh countered the extent to which the state might have relied on a ruling that the Constitution does not require unanimous juries is most relevant for purposes of stare decisis. And Apodaca only stands for that principle if you include Powell's opinion. Kavanaugh also suggested that there were practical reasons to overrule Apodaca. He first cited the unfairness to defendants who were convicted and potentially sentenced to life without a unanimous jury verdict. He also reiterated that the non-unanimity rule is rooted in racism and a desire to diminish the voices of black jurors. Why, he asked Murrell, aren't those two things enough? Similarly, when some justices had focused on what they viewed as the negative effects that might flow from a ruling from Ramos, other justices suggested that the effect of a ruling for the state could be equally, if not more, pernicious. Justice Sonia Sotomayor told Murrell that she was talking about a parade of horrible if we were to rule against you. But what if we rule for you? Would other bedrocks of jury trials that have been long taken as a given, like the requirement of having a jury made up of a fair cross-section of the community, or the requirement that jury find guilt beyond a reasonable doubt, also be open to attack? And Justice Neil Gorsuch took on the state's argument that the convictions of as many as 32,000 defendants could be called into question if the court ruled for Ramos. One might wonder, Gorsuch persisted, whether we should worry about their interests under the Sixth Amendment as well. And in any event, Gorsuch added, he was skeptical about whether the court should ensconce an erroneous view of the Sixth Amendment in perpetuity simply because of 32,000 convictions in Louisiana. Now, during his rebuttal, Fisher tried to assuage the concerns of the justices who may have harbored more concerns than Gorsuch did about the effect of the ruling on Ramos. There are only 36 cases on direct review involving the questions presented in this case, he told the justices, assuring them that they can postpone questions about whether their ruling would apply retroactively to inmates whose convictions had already become final. Moreover, this case is different than an ordinary stare decisis case because the court's splintered ruling in Apodaca was so unusual, it was almost a universe of one. Fisher seemed to have at least 5 votes and possibly more in his corner, but we'll know sometime later this term. I think it's interesting that 2 states, Louisiana and Oregon, are worried about these cases coming back because they didn't have a unanimous jury. They gambled that they didn't need a unanimous jury, and if this case reverses the matter, then they're the ones that have to basically pony up to the table and pay for their bets. They bet wrong. The state should always lean in favor of liberty and holding the government to the highest burden of proof. I personally hope that this case reverses them and Louisiana and Oregon have to go back and do a bunch of trials. Hope you like the show. I know it was a lot of information, but I think it's so fundamental to criminal law. And when these cases get to the United States Supreme Court, it affects cases everywhere. So I thought it was worth talking about. Please like the channel. Please subscribe. Please hit that like button. Hit that little bell if you'd like to be notified. And we appreciate you watching. Have a great day.